I call this hearing of the Senate Communications and Technology Committee to order, and I'd like to welcome everyone to this hearing to discuss data privacy in the Commonwealth and amending the Breach of Personal Information Act. All levels of government rely on the internet to conduct its daily business. Our constituents send vital and important information to our offices and the offices of various government agencies every single day. And they put their trust into those agencies to make sure that their personal and private data is both secure and protected. Whether it's information for a birth certificate, a car registration, or an application for SNAP benefits, it is our duty as public servants to do everything we can to keep that data safe and guarded from any kind of breach. It is incumbent on us to do everything we can and implement all best practices to do just that. This hearing will be essential to learn more about best practices across the country when it comes to data privacy, to be able to implement at the state level those best practices and to ensure that sensitive information that our constituents submit does not fall into the wrong hands. Today, we will hear from the National Conference of State Legislators to learn what other states are using as their data privacy best practices. It's important to know what other states have done right and what they may have done wrong so we can learn from them and implement legislation that has worked. The Mercatus Center, based out of George Mason University, has also provided written testimony, and also they give us various national examples of data privacy trends. Additionally, we'll hear from the private sector. Unisys, a company that specializes in IT security, is here to testify to their best practices, along with written testimony from Microsoft. I'd also hope to hear the state perspective on this issue and have someone from the Office of Administration come to testify today. We did, however, receive written testimony late yesterday, and I will send it out to members following the hearing. I would now like to open it up for some opening remarks from Chairman Carney.
Thank you, Chairwoman. Welcome, everyone. This is an issue which is very timely. If we may already be a little late to the party on this, but it's an issue that's not a partisan issue. This is something that goes beyond Democrats and Republicans. We need to tackle this and deal with it in a serious manner. There are 3 or 4 bills that are floating around the Senate and the House that all kind of deal with this, and my hope is that through this hearing we'll be able to sort out the best from all of those particular bills and move forward for the Commonwealth. So thank you all for coming.
Thank you, Chairman. We're going to have to rearrange the agenda a little bit this morning due to some conflicting committee meetings. And first, we're going to hear from Senator Dan Laughlin, who represents the 49th District in Erie County. Senator Laughlin is also the prime sponsor of Senate Bill 487, which would make updates to the Breach of Personal Information Act. And this piece of legislation is currently within this committee, and I think it would be helpful to first hear from the prime sponsor regarding the intent of the bill, and then also hear from the experts on what other states are doing regarding their data breach laws. Senator Laughlin has a very busy morning and a committee meeting scheduled, so we wanted him to go first on the agenda to make some quick remarks. Thank you for being here today, Senator Laughlin.
Thank you, Chairman Hill. Appreciate everybody's time for, and allowing me to go quickly here because of my schedule. And I thank you for your consideration of Senate Bill 487. With reports of hacking appearing in the news on an almost daily basis, it is vital that we take steps to ensure that our citizens are expeditiously notified if their information in state databases is compromised. Government and the private sector must be prepared to address information security threats from domestic and international hackers. Senate Bill 487, which updates Pennsylvania's Breach of Personal Information Notification Act, sets specific steps that state, county, and local governments must immediately take when there is a breach. Specifically, the measure requires a state agency, county, school district, or municipality to notify the subject of a breach of personally identifiable information within 7 business days following the discovery of a breach of security. In addition, a state agency must notify the state attorney general and the Office of Administration within 3 business days following the discovery of a breach of security. My legislation also requires the Office of Administration to keep a policy for the storage and transmission of personal identifiable information data. With so much personal information out there in government databases, it is essential that we take every step possible to protect that information and to act quickly in those cases where hackers breach those files. Senate Bill 487 sets specific policies and procedures for those cases. And just on a side note, my wife's information was temporarily hacked, and so this bill means a lot to me. And she wanted me to relay this to the committee today. There's a credit report freeze that you can do, and she found that to be very helpful. So she's in the official record now. I think she'll be happy. Thank you.
Thank you, Senator Laughlin. And next, joining us by phone today is Pam Greenberg from the National Conference of State Legislatures. We'll start with Ms. Greenberg's opening remarks. Yes. Senator Laughlin, do you have time to answer a few questions, or? I understand. Thank you very much.
Sure.
Senator Carney?
Thank you, Senator Laughlin. Some of the definitions in the bill, the way they're written, to us appear a little limited. Would you be willing to expand those definitions a little bit to, in terms of definitions of personal information?
Absolutely, Senator. I know no bill that we do is perfect, and if you have some ideas to make it better, I would welcome working with you on that.
Okay, that would be great. And the one thing we noticed too is the 3-day period that you have written in the bill. In our day and age, when information exchanges hands so quickly and things happen so fast, would you be open up to the idea of reducing that time period? 3 days seems like a long time in the way we.
Yeah, I would like to hear from the stakeholders that have to, let the information be put out that there is a breach, to make sure that, they have adequate time to do it. But I'm certainly open to that as well.
Okay, thank you.
Thank you. Thanks for your questions.
Thank you again, Senator Laughlin. My pleasure. Again, Pam Greenberg from the National Conference of State Legislatures will be with us, and we will start with her opening remarks. And Ms. Greenberg, you should have plenty of time for all members to ask questions.
Okay, thank you. And if I may ask, are my slides showing for everyone?
Yes, they are.
Thank you. Good morning again, and thank you for inviting me to be part of this hearing. My name is Pam Greenberg, and I research technology and privacy issues for the National Conference of State Legislatures. I'm pleased to talk with you today about how state legislatures are approaching government privacy issues. Next slide. Based in Denver, NCSL is a national bipartisan organization supporting the work of both legislators and legislative staff. And as with all of our work, we do not recommend specific policies or legislation on privacy issues. Rather, we provide 50-state research and analysis. Next slide. So based on my understanding of your hearing today, and as I understand from earlier, I will be providing a broad overview of privacy laws as they apply to government. There's been a great deal of focus on consumer privacy issues recently with the Comprehensive California Consumer Privacy Act that just became effective last month, and the European Government Data Protection Act, which became effective last year. So even though I'm focusing on privacy laws that are aimed at state government, there's some parallels with these recent consumer privacy laws that I may touch on. Next slide. State governments hold billions of records with personal information, and citizens are often required to provide certain types of data to state government agencies. So protecting that information is critical to maintaining the public's trust in government. Citizens provide social security numbers, driver's license information, health records, tax information, and so again, very critical information. Next slide. And there are a number of risks to state government data. Technology has meant increased risks as large amounts of data are more easily accessible, and state agencies are attractive targets due to the high value data that they hold, such as social security numbers and health information, the large volumes of data, and in some cases weaker security due to challenges with budgets and staffing. Next slide. And state and local governments are seeing an increase in cyber attacks. One study found a 5-fold increase from 2018 through 2019 in ransomware attacks. The online news source States Group has developed an interactive map of reported public sector ransomware attacks going back about 6 years. If you click on the green dots when you're live on that website, it pulls up details about each attack against public sector entities in those areas, those states. And it will provide details like the amount of the demand and if it was paid, if known, those kinds of things. Next slide. And data breaches continue. Government holds the top spot for security incidents and breaches. 75% of hacks are perpetrated in the government sector, according to Verizon's latest annual data breach report. And you'll see these are just a few examples of some of the large breaches that have occurred in state government. Next slide. And then according to this November survey by the Pew Research Center, a majority of Americans think their personal data is less secure now and that data protection poses more risks than benefits, and they believe it's not possible to go through daily life without being tracked. 78% of U.S. adults say they understand very little or nothing about what government does with the data it collects. And so unfortunately, this lack of understanding can make it harder for government to build and sustain public trust. So citizens need to believe that government will be a good steward of their data and use it in beneficial ways. So what can state government do to counter these kinds of concerns and challenges? Next slide. Well, I'm going to talk today only about a few of the existing types of state privacy laws. Because the U.S. takes a sectoral approach to privacy protection, if you were to list all of the types of state laws that address privacy, you'd see a long, long scroll that lists laws that address health privacy, driver's license records, social security numbers, automatic license plate readers, and I could go on and on. But instead, I'm going to focus on these 5 categories of laws that apply statewide to government data. Next slide. So the federal government enacted a Privacy Act in 1974 that regulates the collection, use, and disclosure of personal data by federal agencies. It does not apply to the private sector. At least 7 states have adopted somewhat similar variations of this act. Again, they apply only to state agencies. But they codify at least some of what are known as fair information practices, long-standing principles about how personal information should be treated. So some examples include giving notice of information practices, giving individuals access to and some control over their personal information, providing for accuracy and security of data, and providing enforcement or redress for misuse of data. And while there are a lot of differences, you could think of these state privacy acts as more similar to the new California Consumer Privacy Act that I mentioned a bit ago, which does not apply to government agencies, but which is the first sort of comprehensive law that includes these kinds of fair information practices. So these state privacy acts have been in place for several years in many of these states, and I mentioned on the slide some of the things that they provide for, among others. Next slide. At least 16 states require state agencies or web portals to establish and post privacy policies on their websites. Most require the policy to specify how personal information will be used and shared. And it's likely that almost all state government websites or agencies have privacy policies for their websites, even in states without a law like this. Just to note that many of these laws were enacted years ago when governments first started having a web presence. But more recently, some of these policies still tend to reflect some of the fair information practices that I just mentioned. And then again, the laws require that government websites must establish and post privacy policies, inform web visitors, before collecting personal information about the use of their data, and then inform web visitors if cookies are used, in addition to other kinds of provisions. Next slide. So a much more recent trend has been for state governments to establish a single statewide chief privacy officer position. Chief privacy officers are also increasingly prevalent in the private sector. This chart from the National Association of State Chief Information Officers shows the growth in the appointment of government CPOs since 2003. And the 4 states listed on this slide are those that established the position in statute. The information in quotes, again, are just examples of some of the provisions in these laws that provide for the duties or responsibilities of chief privacy officers in the state. Next slide. 29 states require agencies to have security practices in place to protect data. And sometimes these laws will simply require reasonable privacy practices, but the trend is toward more specificity, such as requiring agencies to develop security policies or standards, to do annual audits or assessments, and to conduct state employee training. About half of the states now require businesses to have security practices in place. Again, this is a growing trend both for laws directed at government and laws directed at the private sector. 15 states also require agencies, before disposing of data, to destroy personal information and make it unreadable or indecipherable. So altogether, there's a total of 33 states, with one or both of these kinds of laws. Next slide. And all 50 states have breach laws that require businesses to notify individuals if their personal information has been breached. And at least 39 states also require state agencies to report data breaches. Some states have a single law that applies to business and government with the same kinds of provisions, while others have separate laws and different requirements for government versus the private sector. However, they require giving notice to individuals of a breach without, typically without unreasonable delay. Some states specify a certain time frame for notification, such as 45 days, 30 days. That's been an increasing trend to name the amount of time for reporting. Also, those with a specific time frame often have a provision that might allow it to be extended if necessary for an investigation of the incident. And many require notice of the breach to be given to an attorney general's office or a central IT or administrative agency. Next slide. So finally, even though breach laws have been in effect for quite a few years, we continue to see legislation that would amend these laws. So, and some of these areas we're seeing are expanding definitions of personal information. So things like health insurance, medical information, biometric information, even mother's name and mother's maiden name. Those kinds of things are being added to definitions of personal information. They're also adding requirements to put in place security measures, like I mentioned previously, and then adding requirements for contractors or third parties that are holding data, requiring them to report any breaches as well. The next slide. So with that, I thank you, and if I can, I'll answer any questions that the committee may have.
Senator Carney.
Thank you, Chairwoman. And Pam, thank you for taking the time to talk with us today.
Thank you.
Just a couple quick questions about, I know you've identified some of these things already, but I wonder if we could just understand a little bit better about how the standards for how individuals are notified is across, whether we're seeing additional things. There's a couple bills floating around with different time periods associated with that. Also, the question, extending that question to providing notice back to individuals whose data has been breached. I heard you mention 45 days, which seems like a very long time to me.
I'm sorry, I seem to be missing audio.
Uh-oh.
Oh. There, now I'm
Can you hear me now?
Yes. Mm-hmm.
Yes?
Yes.
Okay. So the questions were about the standards for how individuals are notified and the time period associated with that. I heard you mention 45 days for notifying individuals whose data had been breached. To me, that seems like a very long time if I was someone whose data had been breached.
Yes, there's quite a few states. I would say the most common time frame is 30 days, some 90, 60 days, 30 days, 45 days. Those are different time frames in other state laws. The California recently changed theirs to 10 days. That's the shortest time period that I'm aware of. There may be others. Because the trend does seem to be moving to a shorter time frame. I think one of the considerations is allowing for some time to investigate the incident, to understand whether it's truly a breach or whether it was, accessed and released, or what kind of incident you're facing, and that may take some time. And
Okay.
I'm sorry, was there another part of your question I have not addressed?
No, that's good. The other question has to do with sort of I know you identified a trend about increasing the definitions for personal information. I think that since we're a little late to this game and getting into it now, we probably should have the most extensive definition of personal information that we can have. That's not really a question, I guess, but it's...
Well, yeah, again, excuse me, Senator. I'm getting a little bit of in and out of audio, but I would say that, again, the trend has been to add more information. However, there's some concerns out there expressed by some parties that consistency of a definition of privacy, personal information or personally identifiable information across different statutes is an important consideration as well. But again, not all states do that, and there are certain circumstances that might require different definitions.
Okay, thank you very much, Pam.
Thank you. Ms. Greenberg, obviously data privacy is challenging for any private corporation, but in light of your testimony that 75% of data breaches occur in the governmental sector, I think it's even more challenging when a governmental entity is involved. So governments may not have the same expertise as the private sector, but we also have a change in leadership every few years. How do other states handle the turnover in leadership when it comes to maintaining the confidentiality of data? Often, when the governor changes leadership, it means significant staff changes as well, which goes to the point of maintaining one person or an office within state government that exclusively handles this issue. So if you could speak to how other states handle that, it would be very helpful.
Thank you, Senator Phillips-Hill. That's a really good question. I do know that turnover among state chief information officers, for example, is very high. One of the things that some of the state laws require, data security laws, they require that security standards be established and for all state agencies across the state, so statewide standards. And I think that may be one way of having procedures in place, requiring regular audits or assessments and requiring training in statute could be one way of addressing that changeover in leadership, but still maintaining the requirements and standards that are important to retaining security.
Thank you. So Senator Carney made a very good point, which is we're, relative to other states, perhaps a little behind the 8 ball. Where are we lacking? What could we potentially use as a legislative fix? What are other states doing that Pennsylvania could emulate to strengthen our laws?
Excuse me. I think that, thank you, Senator. I think some of the areas would be in your security breach law. Right now, 19 states include medical information within one of the types of personal information to be included in if it's breached. And other states also require governments to notify the Attorney General's office or a central state agency of breaches. That allows tracking of incidents over time and which agencies might be involved with incidents. Also, I think just the privacy acts that I talked about that set forth certain types of principles and things like minimizing data collected and providing that data collected is being used only for the purpose that it was initially collected and not shared without notification or in ways that wouldn't be considered when someone provides that kind of information. Without sort of hampering data sharing for purposes that might be helpful to state agencies. But again, minimizing data collected, providing for notice, those kinds of things that are in the Privacy Acts, state Privacy Acts are another area that's probably we'll see more of, given consumer privacy laws that are on the horizon. One of the things that I saw with security breach laws is that initially they were directed at businesses, and once many states had those kinds of laws, they began looking at getting their own house in order and making sure that agencies were also providing for notification of breaches.
Well, and that really led into my next question, which is giving constituents confidence when they hand over information to government. So, privacy policies and notifications on how data is used or when it's shared obviously would go a long way to reassuring our constituents that, government is responsibly handling their information, right? We don't have a choice whether or not we hand that information over to a governmental entity. We do within the private sector. So I just want to finish up with one last question, and it's to my earlier point about a change in leadership every few years. There is also the worry about destroying data after it's no longer needed. Do other states follow private industry best practices on this? how do they typically handle the destruction of data after it's no longer needed anymore? And is it specifically written into their data privacy laws?
Thank you, Senator. Yes, I guess I can't address directly how it's done in states, but I do know that quite a few states do have provisions for safe data disposal in statute. And in fact, about 15 states provide specifically that the data, when it's no longer being used, must be disposed of properly, must be made indecipherable. So electronic records must go through certain kinds of cleaning and making sure that that information is purged before it's disposed of. And that some of those also apply to paper records because, as you know, paper records can be a significant source of data breaches as well.
Sometimes in this day and age, we tend to forget that. So, Ms. Greenberg, thank you so much for taking time out of your day to be here with us and testify. We really appreciate it.
Thank you so much.
And we'll now move on to our last panel of the day. And joining us for this part of the discussion is Clifford Shire, Managing Principal Security Solutions, Enterprise Solutions at Unisys. So, Mr. Shire. Mr. Shire, thank you for being here. And again, we'll start with your opening remarks, and then we'll have members ask questions after. Mr. Shire, I don't mean to interrupt, but could you please make sure that your microphone is on?
How's that?
Much better, thank you.
Shall I start again?
Please do.
All right. Chairman Phillips-Hill, Chairman Carney, and members of the Senate Communications and Technology Committee, thank you for the invitation to testify before you on behalf of Unisys regarding data privacy. It is Unisys' position that collaboration on data protection and privacy is both urgent and timely. Steps toward positive outcomes for data protection and privacy, and assurances communicated in this regard will bolster public trust and the reputation of the Commonwealth's government entities. My testimony will provide a measured perspective on the general topic of data protection and privacy, and will do so regarding key aspects of the inherent disciplines, risks, and responsibilities. Within the time constraints of this hearing, it will not be possible to cover disciplines such as data classification and data lifecycle management at depth, but I will highlight some of the nuances that data privacy regulation brings to the forefront and am open to participating in further dialogue on these matters. My name is Cliff Shire, and I am a resident of the Commonwealth, having lived in Monroe County for more than 17 years. I am here today representing Unisys Enterprise Solutions Consulting Organization, and as an experienced Chief Information Officer and Chief Information Security Officer, am a trusted advisor to our client CIOs, CTOs, CISOs, and other senior IT leaders. In my role, I provide thought leadership and strategy on topics such as the governance of enterprise IT, risk, compliance, security, and privacy. I have been called upon regularly by Harrisburg University of Science and Technology and their Government Technology Institute to lecture on topics such as these, including as presenter and panelist at their Data Privacy Day event last week. The Commonwealth is one of my clients. I have had the privilege to advise and provide guidance to the Commonwealth's Office of Administration, IT delivery centers, and other agencies. Unisys is a global technology leader, well-rooted and with a long-standing headquarters in Blue Bell, Pennsylvania. Importantly, Unisys is proud to be a trusted advisor and supplier of IT services to Pennsylvania as the Commonwealth's largest technology partner. It is safe to say that our experience in the Commonwealth and across the world has enabled us to understand best practices for data protection and privacy. These best practices help drive efficient, effective, and sustainable IT outcomes with better understanding and decision-making, greater coordination, and cooperation amongst state entities and between the public and private sector, enabled by efforts that enhance value that IT can deliver, while doing so in a manner that reduces risk. As background to my comments here today, I'll provide some context in brief. Regulations commonly refer to personally identifiable information, protected health information, or personal information in general. But central to the theme is the core consideration of who actually owns the rights to the data. And in that regard, the regulations are trending toward favoring the data subject. In other words, affording rights to the person whose attributes are recorded and responsibilities to the entity that is in possession of or tasked with processing that data. This is important to be aware of because it subsequently obligates organizations, and particularly IT within those organizations, to think differently about data, how it is protected, and how it is shared. In broad terms, this data would include items recorded with or without implicit or explicit consent, which are capable of connecting the dots to directly or indirectly identify a person, that person's descriptors, status, or activities, regardless of who initiated the creation, acquisition, or capture of the record, the transaction, or other tracking information. There is an inseparable linkage between security and privacy. The data protection that has been afforded by security sits squarely within what is known as the CIA triad, which is comprised of confidentiality, integrity, and availability. Yet many of the latest privacy regulations contain guidance and requirements that extend the need for systems functionality beyond data protection. As children, we've all learned that sharing our toys is a good thing. We've also been scolded by our parents for sharing too much of our private family information with others. These are the two sides of sharing. And that was likely the earliest occasion that we learned of the need for data privacy. We share when appropriate, with permission, honestly, in context, and so on. Organizations both in the private and public sector are in possession of data that was gathered at some point for a particular purpose, but continues to simply exist, lingering on in perpetuity, awaiting some potential future useful purpose. Possession of data endlessly presents a significant risk to both the organization and the data subject. This is where disciplined data classification and data lifecycle management become necessary. It is difficult to protect data without identifying what the data contains, classifying it accordingly, managing where it is, and ensuring adequate governance and stewardship of that data. The concept of a well-defined and fortified perimeter no longer exists. When business units directly engage to use systems as a service or other cloud solutions that are apart from IT awareness, governance, or management oversight, these occurrences of what is known as shadow IT multiply the data identification and classification conundrum. In order to protect data, especially when data has not been completely identified or classified, or when data is shared into systems managed by other parties, whether that party is internal or external, it is good practice to ensure that foundational safeguards are put in place. The concept of zero trust has become mainstream. Just like it sounds, trust must be validated and earned continually. This speaks to necessary disciplines governing the entire life cycle of the data that go beyond assumptions or delegation of that protection. Technical controls to limit potential exposure, such as microsegmentation of the network, dynamic isolation of data according to use case, and of course encryption for data wherever it exists or is in transit, is of course well advised. Data lifecycle management is an enterprise policy-driven approach that seeks to define stages of progression in the life of data. It is generally portrayed as a neatly defined cycle from the birth of the data through its ultimate transfer, archival, deletion, or destruction. Traditionally, this cycle has managed sets of data, like a file or a database, but now also requires the ability to more granularly identify, extract, and/or expire individual data items from within the data set. Recent and evolving privacy regulations have prescribed use cases to be adopted at multiple points throughout the life cycle, and even ahead of the life cycle. As an example, in preparation for creation, acquisition, or capture of data. An example of the use case would be something that would include the timely removal of data items that no longer align to an intended purpose, rather than the perpetual possession of data simply because it may someday be useful for other purposes. Much of this privacy-related systems functionality, or allocation of financial or personnel resources to service those processes, has not historically existed. As current and new legislation is knocking at the door, or even ready to break down the door, modernization of systems and the retirement of legacy systems must be top of mind and need sufficient resources allocated accordingly. While both security and privacy would be best designed into systems early, even at the outset, legacy systems are not provided a free pass. Resources aside, it is a daunting effort to retroactively incorporate this functionality into many of the existing systems and processes. That's the technical side. But let's apply this to risk. The risk to any individual or organization, private or public sector, has never been greater. The reputational and economic exposure has grown exponentially. And neither individuals nor organizations are adequately prepared for the consequences of the severity of the possible negative outcomes. Senator Laughlin spoke of one in his testimony with his own family. News reports of breaches have become a near daily occurrence. Most of us have been issued new bank cards at one time or another well in advance of the expected expiration dates as a response to some of these breaches. And worse yet, when protected or private personal data is shared because it can be, not because it should be, the opportunity for misuse escalates, along with the risk of reputational damage and, of course, the possibility of litigation. Unisys has for the past 13 years conducted a regional and global survey known as the Unisys Security Index. The 2019 Unisys Security Index is based on national surveys of representative samples of 13,598 adult residents aged 18 to 64 years of age. Regarding the individual, this year's results indicated that globally 69% and in the United States 63% of the respondents are either extremely or very concerned about identity theft. This number is increasing, and this is the category that is ranked highest on the chart, significantly higher than even personal safety. which in comparison scored only 49% globally and 42% in the United States. I have included a copy of our survey with the transcript of our testimony, as it can provide further insight and information on how individuals view security in today's operating environment. Although being somewhat desensitized by the breach after breach of their data, these threats are real, and individuals are rightly concerned. Lives are impacted significantly more than a subscription to a credit monitoring service will solve. This fear is fueling the push to define who really owns the data and to regulate its classification and ensure a carefully controlled life cycle. In response, organizations need to be aware of the true level of their own economic exposure, whether due to fines or the overall impact. Sufficient resources can only be made available to solve data privacy issues when this risk is credibly quantified. Effective methods to quantify this risk do exist, and establishing this discipline within any organization is highly encouraged. If Equifax had known that the cost of their 2017 breach would exceed $1.3 billion, they would have likely insured themselves for more than just a tenth of that amount and established greater rigor and posture. In conclusion, this serious level of concern toward identity theft can be interpreted as but a symptom of something deeper. The issues and concerns around data privacy come down to matters of trust regarding data and its use, misuse, or disclosure. Data protection and privacy regulations have come to exist because of this mistrust. In order to ensure that organizations are equipped to reach the high bar set by these regulations, there is a need to ensure commonality and consistency of expectation across the domains of authority, and a centralized point within the Commonwealth responsible for collecting and maintaining information on data sharing and breaches to better inform policymakers of the true scope of the problem and thus the risk exposure that the Commonwealth faces. Collaboration is necessary across the Commonwealth, its constituents, across states and federal government, and together with the private sector. Otherwise, organizations will be hard-pressed to accomplish the behaviors that the well-intended legislation had aimed to achieve.
Mr. Shire?
Yes.
If I could, Senator Carney has to get to another voting meeting today and has a couple of questions that he would like to ask. If we could suspend your testimony to be able to answer his questions, I'd really appreciate it. Thank you, Senator Carney.
Thank you, Chairwoman. My apologies for butting in like this. I think at the core of what I understand from your testimony is this sort of, that there's a disconnect often between legislation and laws and sort of best practices that occur within companies dealing with data. Companies can establish best practices which take into account context and nuance in a way that is often difficult for government to try to get to. I wonder if you could just sort of comment about that.
That relates to my comment in regards to collaboration just a moment ago. Collaboration is necessary across many parties. We applaud Senator Laughlin's desire to update the personal notification, the Breach Notification Act. Any updating of those acts is certainly a very positive thing. The need for collaboration to understand both the intent in regards to placing a greater protection on security, on notification, a protection of individuals, protection of data is all important. But it's also important, as you had mentioned, to recognize that there are organizations who do need to comply with these regulations. And if regulations are not common or collaborative across the different authorities, it is very difficult to comply with those. Organizations typically have a very limited budget to deal with, public sector and private. And from that standpoint, there is often the push and pull between two things, either complying with regulations and doing the right thing, which of course requires investment of funds, investment of people, investment of time, against the potential fines or breach-related costs. So when those considerations come into play, we, of course, at Unisys stand on the side of aiming to do the right thing and to do the right thing right. And that's why the collaboration is necessary to ensure that organizations, again, whether private or public, do have the capability to be able to respond accordingly and to be able to protect the data.
Well, I appreciate that, and I appreciate your willingness to be a collaborator on these kinds of things. My last quick question is about time periods. In terms of, there's some questions about notification, for example, when an agency within the government discovers something, how long until they have to notify the appropriate people, whether we have a chief information officer or how that kind of works. There are several bills besides Senator Laughlin's, which are around, which have take different attacks at that. Senator Laughlin's, for example, calls for a 3-day thing, and I have the feeling that it probably should be closer to 2 hours as opposed to 3 days. And then on the flip side of that is, when is government, when do we notify individuals that their data has been breached? And we've seen everything from 90 days to, I think the most aggressive one is 10 days in California, is what we heard in an earlier testimony.
Well, certainly the easy answer is in a timely manner. The difficult answer, as you have certainly identified, is that there are so many different views on what should be a timely manner. There is a certain degree of verification that needs to take place. There are many statistics that indicate that breaches occur long before they're detected. So certainly being able to respond to that in a timely manner would be key. There are varying types of information. So there are also varying positions on how severe that information being publicly released or disclosed or misused would be. Again, as early as should be practical to do so would be the answer. That would have to be negotiated across.
Okay, maybe that'll be a collaborative point.
That would have to
we
be,
can move
yes.
forward. Thank you very much for your testimony today. I'm sorry I got to get to the other side of the Capitol in 3 minutes. So
My pleasure. Okay. Thank you very much for your questions.
Mr. Shire, we, of course, are going to run into the Bewitching Hour. I have many, many questions, and really appreciate you being here today. We were told by the Office of Administration that there's currently no one handling data privacy for the Commonwealth. So I'm curious what your experience has been, being that the Commonwealth is one of your clients, and talk relative to what other states have done in terms of a data privacy ombudsman, a deputy secretary. Our Commonwealth is handling so much private and personal information, and I think there's consensus that it's incumbent on government to make sure that there's someone at a higher level managing that data and making sure that it's safe for all of us. So could you give us some perspective on other states' approach?
I can't give you a lot of perspective on other states, primarily because the Commonwealth is my client, not necessarily the other states. However, I will say this. From the testimony provided by the Office of Administration, they have clearly noted that security and privacy are often used as interchangeable terms, but they are not interchangeable. They do have differences across what they do. Security primarily focuses on the protection of the data. Many of the privacy regulations deal with a lot of functionality aspects. It is not that the Commonwealth does not have anyone handling privacy, because again, privacy is a concern within IT and has always existed as a concern within IT. It's part of how data is protected and the sharing is carefully monitored and managed. However, if the indication of your question was that there was no common point at which privacy is held to account or held to from the standpoint of an ombudsman or what have you, as Pam Greenberg mentioned in her earlier testimony this morning, other states have suggested an auditor general. It would vary from organization to organization how the organization structure is set up, but it should be a common point that would be able to recommend, inform, and provide other related context to the senators and other powers that be within the government.
Thank you. So is data privacy for the Commonwealth currently being handled by each individual agency? So you probably know that our state's been subject to multiple data breaches. We had the Department of Education in the TIMS system, Department of Corrections, Department of Human Services. We could go on, even the General Assembly. So clearly it's a Commonwealth-wide problem that needs to be resolved. Should there be one single system applied uniformly across all agencies, or is it better for each agency to implement its own protocol? It seems as if each agency has its own problems with protecting data. I think it's probably time that we start addressing it in some capacity. How do you think best to address it?
Different agencies will deal with different data, right? So because they are dealing with different data, they're dealing with different implications of that data and perhaps its disclosure. The same thing is true of sharing. Data should not simply be shared if it is out of the context of the original purpose for that data, without being able to be clear with the data subjects how that data is being used. As I had mentioned early on, the aspect of public trust. Public trust is important, and when the understanding of how data is being used and shared across agencies, that will bolster public trust. And that's certainly beneficial to the government as a whole and all of the government entities. One of the things that I would say is that a lot of it is based upon principles. What are the core principles that need to be enacted across the different agencies? And what are the nuanced differences based upon the different data that actually is contained and maintained within those agencies? The other thing, what I would say in relation to something that I've said earlier, is the fact that a lot of times data simply lingers on in legacy systems. A focus needs to exist on ensuring that that data follows the appropriate path at the end of its life cycle, not simply lingering on, because that poses risk of breach to those agencies themselves as well.
Can we go back to the point in your testimony where you said you talked about this inseparable linkage between data privacy and data security? I completely agree with you. I think that too often the Commonwealth jumps to data security without looking at that full picture of what we need to do to keep that data private. And we can't know what to keep private if we don't know what that data contains, which goes into your last response. So can you go through those steps that you think the Commonwealth could use to make sure that the data is not only secure from breaches, but also private? So how do we go about implementing, you talked about the public trust, notifying people about how their data is used, how it's shared, and that would take you to that point where you engender the public's trust in terms of us securing their data.
Security and privacy, as you have so stated and was in my testimony, is intertwined in many different ways that they have to interact with each other. It was always historically a matter of data protection. How do we protect that data? When we're thinking of breaches today, oftentimes we think of it as far as a hacker coming in and affecting from the standpoint of some system that should have been secure. I'm sure many chief information security officers would love to point at the chief privacy officer at that moment, but that's not necessarily the case. However, as far as the privacy regulations and the privacy regulations that are evolving over the course of time, a lot of the focus now becomes upon functionality. So it's not simply the protection of the data, but it's how that data is functionally viewed, functionally accessed, shared across organizations, and perhaps perceived from the standpoint of its purpose, intended purpose, or perhaps a future purpose with some explicit approval to use it for that purpose. The data owner, as the data subject, certainly has certain views in that regard. And those views are unifying. That is not certainly a divisive view from people. People do want data privacy. But a lot of it comes down also not just to technology, not just to automation, but also to people, because that's where the decisions are being made. You want to certainly focus upon the means to make good decisions. And those good decisions, again, I have to say again, need to be collaborative in how they come about.
And I have one last question
Yes.
to ask. It's probably a multi-part question, but do you have any suggestions for legislation that could better improve data privacy in the Commonwealth? Are there trends that you're seeing in other states that have worked well? Are there gaps in our existing structure that we could use a legislative fix? We're the ones that can make that fix. We want to make sure that all of our constituents' information is as secure as possible. And, you know, we certainly would never say that we are the experts here in this building on what we need to change. So lay out what you think the path forward to improving our security and our privacy are.
One of the things that Pam Greenberg mentioned in the earlier presentation of her testimony was that states typically have segmented their policies. And by segmenting their policies, there are a number of different ways to approach security and privacy. Looking at it from a much more common perspective and ensuring that in some way that there is a common, principled, collaborative review of those acts and policies that exist will certainly benefit a direction forward. Because once again, the IT organizations need to be able to comply with these. They need to be able to hit that bar that the legislation and regulations have placed before them. So to be able to hit that high bar, they need to be able to adopt those in some fashion commonly across what best practices are and what common practices are.
Mr. Shire, thank you so much for being here today. This has been incredibly helpful, you know, and we know that we can always reach back out if we have any additional questions after all the committee members read the testimony. Really, really appreciate it. So I'd like to thank everyone for participating in today's hearing, and I will now recess the Senate Communications and Technology Committee to the call of the chair. Thank you.